Hi, good morning. I'm Dan Margolin. I'm going to be talking about the legal issues of divorce with you today. I'm a lawyer at the firm Stevens Margolin PC. We have an office in downtown Portland, and the firm focuses solely on divorce and family law issues in Oregon. I have a practice that stretches from litigation cases through to appellate cases, and I also focus on collaborative divorce and different types of ADR issues. There's an agenda I want to go through today, and I'm just going to give you a brief layout of that. It's going to involve first going through what the issues are in a divorce, what the process of a divorce is, what the different ways to resolve a divorce is, and things that you can do before divorce and afterwards to make sure that you're in the best place possible. So, the first issue is what is a divorce? In the state of Oregon, a divorce is a way in which the court dissolves your marriage and makes it so that you're a single person. Involved in that is a division of your finances, dealing with how to allow people to support themselves after the divorce, and what to do about kids. Um, I'm going to start with the asset and spousal support part so that that can be focused on because that is relevant to everyone, and the kid stuff I'll get into at the end. So the first issue is how to divide your assets and debts. And basically, this is the court looks at you as a corporation almost. It's an unemotional process. And in the state of Oregon, the division is what's just and proper under all circumstances. Now, while generally that means a 50-50 division of assets and debts, it doesn't have to. It's really looking at you as a family unit and what's going to make the most sense for your family. Um, there are certain classes of assets that are treated differently. For instance, if someone receives an inheritance, that can be treated as something that's out of the whole marital package completely. If someone receives a gift, and there's an analysis that's gone through to figure out whether or not those things are part of the marital assets. In addition, if either party brings something in premaritally, if someone has a bank account with X numbers of dollars that they had before the marriage and that they've left alone, oftentimes that can be treated as separate from the marital property. In addition, if someone has a 401k or other retirement plan, whatever's in it to start stays out of the division of the marital assets, although it can be considered. And so the important thing to remember is that you're looking at all of the assets out there, and it's important to know what they all are, because the three things we do is we identify the assets, we value the assets, and then we decide what to do with them. And when I talk about an equal division of assets, I don't mean that every single thing's sold and split in half. I mean that you look at the whole picture, including debts as well, and I'll talk about those in a second, and see what the way is where at the bottom of the balance sheet it's going to be basically equal. With regard to debts, they're also treated similarly to assets, where they're generally divided equally. But there are a number of exceptions with debts. For instance, if someone can prove that one party spent all of the money on a credit card for their own personal gain and not for the benefit of the marriage, that can be something that they might have to keep alone. Also, if a debt is attached to a certain asset, for instance, a house often has a mortgage, that mortgage is going to travel with the house. Generally, with the house, that's done by adjusting the marital value of the house by subtracting the agreed upon or assessed value or appraised value and subtracting the mortgage or other encumbrances to reach a final number. The division of assets can be pretty complicated. There's been hundreds of cases written about it, and it takes a lot of thought to do it properly because you have to take into account tax issues. You have to think about what the best asset is going to be for you going forward. And it's important to have advisors that help you do that in a way that's unemotional so that you're not making decisions that are going to have harm for you in the future. One way to do that is to use financial advisors, CPAs, and other divorce mediators, certified divorce financial analysts to help you figure out during the divorce and to assist your attorney in figuring out the best way for you moving forward and the best package for you and for the family. The next issue in a divorce is spousal support. And spousal support is really something that's one of the most difficult parts of a divorce process. And it's difficult for a few reasons. One, it's very emotionally charged. Number two, it creates an entanglement where both spouses are still locked together into the future. And number three, there's no calculator. It's not like you can plug in the numbers and have something spit out. It's very random. If you go to trial in a spousal support case, the judge is in a good mood that day or if they had their coffee or not, it can change the results by a huge amount. And if you go to a few different judges in the same courthouse, you can have wildly different results. It's a very fact-dependent analysis, and it's really important because it can be very scary for a spouse getting out of a divorce where they were financially reliant on the other spouse, and this is their only way while they're getting themselves set up to make do for themselves. A lot of things go into spousal support. There's issues about people's health, future earning capacity, what the amount of money someone has been making, childcare responsibilities, and those sorts of issues are all part of that analysis. Some of the tools I use to help my clients in making these sorts of decisions are to use CDFAs, to use a person's financial planner, CPAs to look at the tax issues so that the client can know that the money that they're going to have is tied to something that makes sense. And part of that is figuring out a budget. And that's a really crucial thing to do, is to know exactly what your needs are, not just now, but what your needs are going to be in the future, and to really think through that in a clear manner. Spousal support's an issue that in a litigated process is often one of the few remaining issues that gets tried in a case. And I don't think that has to be if people do the work on the front side to figure out what their real needs are and what their interests are and what's going to make them be self-sustaining into the future. The other issue with spousal support is that there can be a lump sum as part of the division of assets to take care of support. And in order to figure that out, there has to be a present value calculation. And I'm not going to get into that because there's some complicated issues there, but there's some other ways to deal with support rather than just figuring out a number in a period of years. And on the duration issue, spousal support can be for a set period of years. There can be step downs, a certain amount for 3 years, then a lower amount for 2 years, etc. It can be for an indefinite term where there's just a number that's the monthly amount and it goes on for forever until something else happens. In any event, spousal support always ends when either party dies. Something that people ask me a lot about is, what happens if my spouse gets remarried? And in Oregon, unlike some other states, remarriage does not create an automatic reason for spousal support termination. It is a change in circumstance that the court can look at, but it's not a guarantee. Although parties can agree to have anything in their divorce that they want, and for instance can agree that if someone gets remarried, that will result in termination. With spousal support, there's 3 types of support in Oregon. There's transitional, compensatory, and maintenance. Transitional support is designed to assist someone in getting back into the workforce or growing in their current employment to make more money. And there's usually a clear reason tied to transitional support to figure out the amount. Maintenance support is designed to allow for a spouse to continue living in a manner not overly disproportionate to the way in which they lived during the marriage. That doesn't mean that you're going to drive the same car or live in the same exact house, but you're supposed to be able to live in a similar way. And compensatory support is becoming more common in Oregon, but it's a very small percentage of cases. It has to do with a party providing the ability for the other spouse to earn more money in the future, or to have gained certain job experiences that they're going to continue to use that were based on the contributions from the other spouse. These are all issues that someone needs to have a conversation with a lawyer to really understand the breadth in their case. But it's important to know of these different classes of support out there. The last thing that's important about support is that the person receiving support has to pay taxes on that support, and the person paying it gets to take it off of their income for the year. So those are really the 2 big financial, non-children issues in a divorce: the asset division and spousal support. That leaves us with the issues regarding children. And there are sort of 2 classes of issues. One is, how do we decide about the kids and where do they spend their time? And the other is the financial component of child support. On the first part of the child issue is custody and parenting time. And I'm not going to spend a lot of time getting into the specifics of parenting time because that's going to be covered by another speaker a little bit later. One thing I find when people come and meet with me is that they have a lack of understanding of the difference between custody and parenting time. In the general community, they're thrown around as being pretty similar, but in legal terms, they're very different. In Oregon, custody is legal decision making authority. It has to do with deciding where a child goes to school. Are they homeschooled? Do they go to private school? And what sort of medical decisions are made? Are they going to have this vaccine or not? Is this operation going to happen? In Oregon, there's two different types of custody: joint custody and sole custody. Joint custody means that both parents agree that they're going to work together to make all decisions, and neither of them can decide anything on their own. That means that if Mary wants Susie to go to private school, Mary and her ex-husband are going to have to agree on that. And if either of them disagree, then Mary can only have Susie go to school where they both agree. Same thing with medical choices. Joint custody cannot be ordered by a court. It can only happen if parties agree. And the reason for that's pretty simple. A court feels if you're in court, you already can't agree. And so the court's not going to put people in a place where they're going to have to agree on things going forward. Sole custody is where one parent has the unilateral and sole right to make those same decisions. They're still encouraged to talk to the other parent about these things, but they don't have to. And the other parent's viewpoint doesn't enter into whether that person makes the decision or not. They just get to make it. So that is about legal decision making. It has nothing to do with where a child lives. It is quite possible under Oregon law for one parent to have sole custody and not to have the children with them the majority of the time. It's rare, but possible. Parenting time is the other component. And parenting time has to do with both the set schedule of the child, where they are from 6 a.m. to 6 p.m. on Saturdays in odd years on uneven months, to, you know, which parent has Thanksgiving with them this year or next year. And at the end of a case, there's a very detailed schedule that's put together in black and white so the parents can look at that and figure out exactly where the child's supposed to be. Now, in a perfect world, that gets put in a drawer, the parents work together, they never have to refer to it, and they can help the child have the best experience they can. But unfortunately, that's not what I see frequently. And what people do is they look at this piece of paper and have certainty about their child, and it makes it easier, I think, for children that they have a set schedule that they can rely on. The other issues in a parenting plan have to do with rules about parenting time, how people should talk, etc. And as I said, there's another speaker who's going to cover those. But the custody and parenting time are laid out in a final judgment in a way that's very clear. And that's one of the requirements under the Oregon statutory scheme in terms of what has to be in a final document. And the last issue is child support. And child support is something that gets talked about a lot with my clients. In Oregon, it's determined by the Oregon Child Support Guideline Calculator. And if you Google Oregon Child Support Calculator, there's a link to it. There's a online interface to enter into information: gross incomes, spousal support amounts, health insurance costs, parenting time, child care, and then it spits out a number. And while parents can agree to deviate from that number, absent an agreement, it's rare that the court does anything different. In the current child support calculator, there's a term called cash medical support. And frankly, it's something that even the legislature, I think, is still confused about. I know that judges are and practitioners, and there isn't a clear, exact sense of what it does. The concept of cash medical support is that it's to cover children's medical needs where health insurance is more expensive than what's reasonable. And reasonable is determined in Oregon by 4% of gross income. So if neither parent's able to insure the children in that amount, there's an amount of money that should change hands to make sure that the children's monthly medical needs are taken care of. Child support doesn't have anything to do with activities, sports, the sharing of other medical expenses, and sharing of other costs. Those things can all be agreed upon and can be agreed upon as part of a child support agreement, but they aren't part of the calculation done by the state. And so it's important to really think through This is the child support number. Is it going to cover everything? And try and work on agreements to cover those other portions of a child's needs. Because child support is set up based on sort of the bare bones national averages of what should be appropriate to assist children. As I said, it can be a very contentious issue, and a lot of people don't understand why it has to be set at this number, why they can't change it. But I think it's important to understand that there is a set law on it, and that if another spouse isn't willing to change it, that there isn't that much leeway there, and it's better to focus how dealing with the entire package things can work out. So what do you do with the information about all those different categories and the way I described that the things happen with them and decisions that are made? Well, at the end of a case, regardless of if you have a collaborative process, if you sit down together and talk with a mediator, if you go into court without lawyers, either way, you come out of the end of a case with a final general judgment of dissolution of marriage and money award if there's a support award or other money to change hands. That judgment encompasses all the things we discussed. It lays out these are the assets that are divided, this is the custody agreement, the parenting plan, the amount of support, and any other ancillary agreements that are part of the judgment. Also, there's a bunch of boilerplate legal terminology. For instance, any wills or trusts that people put together while they were married go away. There's discussions of how, if a retirement account's divided, how that process is going to happen. There's discussions about who's going to be responsible for paying for certain things in the future, how things are going to be exchanged. And once that judgment's done, especially for the property portion, it can never be changed. 2 days later, you can't come back and say, Judge, oh no, I screwed up. It's just done. You cannot modify the property division. Spousal support can be modified by showing of a substantial change of circumstance. And it's a technical legal issue, and since we're not talking about post-judgment things, I'm not going to get into that in detail. You can feel free to call me or email me outside of this to talk about that. But that judgment is the piece of paper at the end that has all the meaning and that actually divorces you. The process starts with someone filing for divorce, and it ends with that judgment. And in between, there are different ways that a case can be resolved. And the petition itself doesn't even have to be filed until total agreement's reached. You can work everything out and then file. But the steps begin with a petition and end with a judgment. It's important to think through the different ways that you can make it down those steps. There's the old school way of going to a lawyer, filing for some papers, serving your spouse, and then fighting it out in the court system, having a trial and a judge banging their gavel and making a decision. On the other end, you and your spouse can walk down to the courthouse, fill out some papers, and be done with it that way. In the middle, there's a lot of different ways to deal with these issues. Parties can sit down together with a mediator without lawyers. And I know that's going to be addressed later in the program, so I'm not going to talk about that too much. There can be a situation called collaborative divorce, and I'm going to get into that in detail in a second. It's really a whole separate manner of dispute resolution. You can have lawyers involved and sit down together before anyone files to try and resolve things. You can file and then have lawyers sit down and mediate the case with a professional mediator that assists you and the lawyers reach resolution. Another form of that type of mediation is a judicial settlement conference, where everyone sits down with a judge, not at a trial, but where the judge helps try and facilitate resolution. And then if that doesn't work, there is a trial. Also, where there are child issues involved, all counties require the parties take a parenting class and then engage in some form of mediation. And most counties have a mediation program where a social worker or other trained person sits down with spouses to try and figure out the parenting components. Along the process, there are certain hearings that can take place and certain agreements that can be reached called temporary agreements. For instance, who's going to stay in the house? How are the kids going to have their schedule while the case is pending? And those can be worked out in any of the sort of systems that we just talked about. I want to take some time to talk about the collaborative practice method because I think it's an important area that people in the community don't know that much about. Um, in my practice, I do litigation, collaborative, and appeal, so I really see everything. And while there are certain situations where collaborative or mediation type practice might not work with abuse or other power imbalances, the collaborative practice model takes you out of that entire court type system. In fact, it started by people sitting down together and agreeing in a contract that they're not even going to go to court no matter what. Obviously, at the end of the day, a judgment has to be filed with the court, but no one's going to run down to the courthouse and get people served and things like that. Um, Unlike the more traditional ways that I described, which are places where people take positions on issues, in the collaborative practice model, the idea is to look at needs and interests and negotiate based on those to look at a best outcome for the family as a whole. And I've seen in cases where that really does work, where a case that if it had gone through a trial process, um, the state of Oregon and its laws wouldn't necessarily have made things work as well for that family. And the other benefit of the collaborative model is that you bring in team members. You can do this in a regular case, and I'm going to talk about that in a minute. But in the collaborative model, parties can have coaches that help them through the process emotionally so that their lawyers can focus on the legal aspects and they can be emotionally supported. You have the ability to deal with emotional issues, which the court really thinks of emotion as being a just unfortunate, inconsequential side product of the divorce process. You can make sure that you thoughtfully think through all of the different issues that are out there and really brainstorm through what goes on. And the way you do that is in what's called four-way meetings or six-way meetings, depending on how many of the different team members are there. And everyone sits down together, usually for 2 hours, discusses the current issues in the case, figures out what other things need to be worked on, and throughout that process, agreements are reached and then a final agreement on how the entire case and process should be resolved. I think it's important that people really consider the different types of divorce resolution models that are out there. And it's important to meet with an attorney who knows about all the different aspects of mediation that can be dealt with. The other part of collaborative divorce is that you use neutral professionals. For instance, there could be a neutral child specialist to help people work through parenting issues. There's almost always a neutral financial person who sits down with the parties, whether with the attorneys, often separate, and works through budgets, assets, all of the information so that the parties can know that neither of them are having someone sort of advocate and make numbers slant one way or the other. You really have an objective, neutral person who's focused on your needs and interests to help you look at the bottom line in a way that supports everyone. And that's far more productive sometimes, or frankly always, than in the litigation model, where if you're talking to financial professionals, you're still trying to have them sway things towards you. And without looking at the whole package, there can be things that are missed where there's money left on the table that both spouses could have benefited from. And it's a shame when that happens. And the collaborative method, because it's paced and thoughtful, makes sure that none of those things are left out. Collaborative isn't for everyone, just like litigation isn't for everyone, or mediation. And what's crucial is that people are informed about all the different models that are out there. Sitting down for a consultation with an attorney, one of the things that you should ask is, please tell me about the different types of dispute resolution, collaborative and traditional. So that brings me to a few other issues about preparing for divorce. I know that a lot of you here are just thinking about whether or not to get divorced and thinking about what the process entails. And there's a few things that can help you, whether you're sitting down with a mediator, sitting down with a financial neutral to start, sitting down with your CPA, sitting down with a lawyer. And that is to find all the financial information that you have online or in your home, make a copy of it, start a file on your computer. I like it when people have a little flip drive that has everything on it. And also think through what your goals are in the future, what you want to do with your life, what things your kids need, where you want to live, all of these sorts of things, so that when you start the process, you have all the homework done. that's going to save you a lot of money, and it's going to allow you to get off on a foot where you have some goals in mind and you can figure out the way to meet those goals. Some things that can help with that are bringing in early on um, certified divorce financial analysts, maybe sitting down with some form of a coach or child specialist to talk about your kids' needs, thinking through those issues so that at the start you're way ahead of the game and really know where you're at and can be sure that you're going to come out of this in a way that's going to benefit you and your family. And so it's important to do that pre-work. Now, once you sit down with an attorney or someone else, they're going to tell you these are the other things you're missing or other things to think about. But the more you can bring to the table, the better view they can have at the beginning to help set a plan. This also flows into what happens after divorce. Um, Once your divorce is done, you get handed a nice piece of paper by your lawyer. They say, okay, it was nice to meet you, and move on to another case. That's not how it should happen, and I try very hard to make sure that I stay engaged with my clients to make sure that all the things that are needed to be done are done. People have to have new wills drawn up. People have to make sure that the money they're getting is invested properly, that they've thought about what happens when I get my spousal support check. How do I account for taxes? And if you bring in early in a case financial neutrals or CDFAs, if you're litigating, you bring in someone to help with the kids, you bring in a financial advisor, it's going to make that whole back end process much more productive. The thing that I find the most disheartening in my work is where I get a really good resolution for someone and then I talk to them a year later, and because they didn't follow through on that post planning, it's been all for naught. And I just, that's something that getting that team in place early is going to make sure that that doesn't ever happen to you. Um, so we've talked about the process, we've talked about the ways to get to that process, we've talked about what the end result is, we've talked about what the different sorts of assets, support issues, and kid issues there are in a case. Um, my office is located downtown, but I practice throughout the state, and I'd be happy to sit down with any of you to talk more about this, answer your questions via email. You can give me a call. I think it's important that you really listen closely to what the other presenters are going to say today, because while I've shown you the greater picture and sort of the bookends of this process, these other people are going to be able to have some more in-depth information to really help you think through the best way for you to go through this process. So thank you for your time, and it was a pleasure telling you about this.